Before I get started with anything else, I want to acknowledge that today we are gathering on the country of the Nahuatl and Cambrai people. And I want to also acknowledge that sovereignty over these lands has never been lawfully ceded, and of course to acknowledge the responsibilities that this brings as we're having these discussions in the context of the law school. I'm Dr. Ntina Tzouvala. For those who don't know me, I am a senior lecturer here at the ANU College of Law, and I'm also the convener of this series, The Politics of International Law, that is taking place under the auspices of the Center of International Public Law, so CIPL. And today, really exciting to be welcoming two colleagues who have actually taught me pretty much most of the things I know about law and finance, and I'm really happy to have them in conversation. First, our main speaker for the day is Dr. Kangle Zhang. Dr. Zhang is currently a postdoctoral fellow at the law school of Peking University, and he's also a visiting fellow at the University of Helsinki, where he also completed his PhD, which is entitled Not Equal Towards an International Law of Finance, which also happens to be the title for today's talk. Kangle is working on international law and especially critical approaches to international law. He's also working on the areas of international finance, law and development, and the Belt and Road initiative and its legal aspects. And I think Kangle's work, if you want to learn some things about the Belt and Road initiative, would be some of the most thoughtful and informed work out there. And I think that's quite important for Australia. And yeah, today he's going to present basically the introductory part of what used to be his PhD. And the title, as I said before, is Not Equal Towards an International Law of Finance. Without further ado, Kangle, the floor is yours.
Thank you, Tina. Let me try to share the screen. I think this is working. Do you see the slides? Great. So, thanks a lot, Tina, for inviting me and also for creating this opportunity to talk with. I'll go just with the first name. After staying in Helsinki for some time, it's just this first name habit. But I'm just really happy to be here. Also talking to Will for a reason that because of this, I went to read Will's book, which Tina just mentioned. And I enjoyed the book so much of parliamentary constitutionalism or financial constitutionalism. And it's something that I've been interested in looking into, so I'm quite looking forward to the conversation today. So turning to my talk today, this, as Tina was introducing just now, this is based on my PhD, which I finished last year. I've been working on this to come up with a book proposal and to turn this into something more mature. And this is sort of an updated version of what I gave or what I had as a doctoral thesis. I'm also quite looking forward to hearing Will's comments and everybody's questions and comments and suggestions of making this something sort of in a more presentable way as a book and so on. So as the starting point, let me see if I can move this somewhere else. Yes. So this is sort of the familiar story of inequality, right? So this is particularly necessary to think of it right now because since the pandemic, since the coronavirus has led to the global recession, the biggest one since the Second World War, the stock market worldwide have surged at a stunning rate since last year, end of March. And this is perhaps unsurprising that the disconnection between the real economy and the financial market has been pinpointed for leading to the unprecedented income and wealth inequality. So this World Inequality Report 2018, done by the group of economists, including Thomas Piketty, who has been quite helpful, whose work has been quite helpful in shaping my thinking, and also the familiar, the elephant curve and other figures demonstrating the rising inequality. And to capture this rising inequality in the more comprehensive way, especially concerning its connection to the financial market, I suggest that the financial market is linked to inequality in at least two ways. And these are, of course, informed by the work some great people, Piketty's work, and the diagnosis of the central contradiction of capitalism, Katharina Pister's book, The Code of Capital, and so on. So the first way is that routinized operations in the financial market enable a higher rate of return on capital than on labor. And second, the interstate power imbalance entails the risk of disadvantage in human groups that are not prioritized by the international financial economy, while they're inevitably involved in the operations of the financial market. So this is sort of a general description of the ways that the financial market is linked to inequality. And I'll go quickly past this. And for those interested, again, the works of, for example, Piketty and Pister are really useful in helping understanding this. But then turning to the part that, or turning to the intervention that I wish to make. So why, as an international lawyer, an international law researcher myself, interested in this, this universe of finance and inequality? Firstly, isn't the financial market allocating resources and creating liquidity for businesses? And isn't inequality to be addressed by the government through, for an example, tax policies? Well, I think no. Not only is tax policy a domestic issue and a toothless one, as it has been usefully demonstrated, for example, by Zhang in the International Tax Policy book, but also the issue of state intervention is controversial, to say the least. Furthermore, the economic inequality has historical and political roots in the constitutive elements of the international economic system, a legal construction to which the financial market is a part of. And perhaps, to be more descriptive, the financial market operations have international repercussions. For an example, the financialization of farmlands in sub-Saharan Africa and Latin America, which flourished since 2007 and 2008, the global food crisis links the farmlands with the law offices in New York and in London. And it not only replaces the central issues of allocation and accessibility in global food chains with investment and production, but it also neglects the ecological character of farming, a way of living for the local communities. Another example perhaps is sovereign debt. Many poor countries are heavily indebted to public and private creditors internationally, which emasculated monetary sovereignty and the lives of people living in these countries significantly affected. The financial market is international, a space that is both the result of coercion, war, exploitation, and the continuation of such struggles. So as a result of which, or for the reason of which, I think it's justified for an international lawyer to step into the battlefield of finance and inequality. And furthermore, to continue on the conversation of international law, finance, and inequality, I suggest that it's no longer radical today use international law to deal with entities whose activities have international repercussions. First, there's the rise of global law, transnational law, and international regulatory law as new forms of academic inquiry to expand and complement old international law. This challenge emerges from changes in internationally relevant governance in practice. So if it is the task of international law research to grasp forms of international ruling, then it cannot limit itself in the old way. And second, from a historical perspective, public international law is a young discipline. The world of natural law had no difficulty to deal with both the laws of sovereignty and the laws of property. Indeed, Ritualia and the international trade, groceries and trade companies, Vatel and the internal duties of states are all too familiar to international lawyers sitting in this room and listening to this Zoom session. If it was the task of law to deal with significant social relations in the legal articulation, then the international implications of private law, rights regime, or domestic laws and institutions could not be overlooked. And lastly, international law generally is based on private law sources and analogies. In other words, private law and private legal matters are inherently within the scope of scholarly inquiry in international law. So considering these three perspectives in the international law debates, and considering that financial market operations and their international repercussions are relatively foreign to international lawyers, especially the international lawyers that have a predominant interest in the rising inequality, this necessitates an expansion of the scope of inquiry in international law. That is to say, the international law in the critical tradition should devote more attention to international finance. So this is the project that I'm pushing for, that I'm trying to sort of push for, a project of taking a step towards the inclusion of the international financial market within the purview of international law research. So to start with, the international financial market is an international legal construction. The very constituents of the financial system, such as legal tenders, the financial instruments, and the operational relationships in the financial market, are all manifestations of juridical relations. States are central to the legal construction of the international financial market. Interstate agreements and their implicit backing of contractual obligations form the architecture of international finance, even though not all states are equally involved in the promulgation process. So by view this international finance, or this domain of practice of international financial market, as a legal construction opens up the space for international lawyers to engage with this field. So in this way, I suggest a way of conceptualizing the international law of finance, that international law of finance, differing from international finance law as commonly referred to in existing literature, but international law of finance is a field of active engagements by international lawyers with the intertwined network and of actors and rules in the financial market, where they master the vocabulary and grammar of finance, dissect the designed distribution of costs and benefits, and critique the role of law in enabling the distinct bargaining power held by different groups of people, as well as their ability to shape legal permissions and prohibitions. So that is to say, the international law of finance, as I envision it, is a field of communication. It's a linguistic interactive process. It's not just the set of law written, statute written down, but rather it's something that international lawyers, by doing specific and particular cases, mechanisms in the financial market with a particular mindset, that is a concern for distribution, for inequality, and a questioning of, for example, expertise. So this has three, to be more specific, this has three implications. First, the international law of finance embraces strategic formalism, and in doing so, it takes states as the unit of analysis. Strategic formalism seeks to bring economic struggle to the political domain by inviting political contestations to economic and financial arrangements, and by challenging material inequality with formalistic equality. This entails the aesthetic focus on the role of state in enabling mechanisms that exist between the states, beyond the states, apart from the states, and within the states. In other words, international law of finance engages with the diverse complex projects that a multiplicity of actors impose and transpose on the legal mechanisms in the international financial market. It avoids any tendency to oversimplify the actors and activities in the financial market while seeking not to lose sight of the state. So perhaps a little bit of clarification here is necessary, that by saying to have a focus on the state is not to say that private actors or other participants involved is not important, but rather to say that, at least from my point of view, the states are quite behind even the doings of the private actors. And moving on, the second implication is that the international law of finance is more than employing the methods and toolbox of international law in addressing actors and activities in the financial market. Normative concerns for distributive outcomes and inequality as part of a distinct character of the international law of finance. The international law of finance rejects a liberal economic understanding of law that ascribes legal normativity to economic efficiency, which is measured through cost-benefit analysis. It embraces a public law-drawn initiative which positions legal normativity as independent of economic normativity. The idea of legal normativity perhaps raises a question of the authority gap in the international financial system. The authority gap is in the comfort zone for international lawyers, however, if we accept the discursive, temporary, and malleable nature of international law. The authority gap opens space for examining the process of decision-making and the distributive significance therein. And there's some useful works in at least domestic finance, financial regulations done by, for example, Robert Hockett and Sal Omarova at Cornell on the sort of normative nature or the public nature, the normative potential of public finance. And this sort of is an expansion of these ideas into the international domain. And third, the pursuit for international law of finance could benefit from situationality analysis by describing the legal practices in the financial market as it already exists. This idea of situationality analysis was proposed by Odi Koldhonen with the idea of actually looking at what is taking place in financial market practices instead of looking at the field of international finance by looking at the law and looking at what the law says and what the law suggests, but instead try to look at, for example, what the lawyers, what the practitioners, what the traders in finance, in the financial market are dealing with. I suggest that there's an implied ethnographic function of situationality analysis, and this ethnographic function could usefully help international lawyers master the language of finance. So this is perhaps also for resonates with the analyst Riley's works on ethnographic analysis of financial market operations. And these I deem are necessary works in moving towards the international law of finance. And also some other useful works include, for an example, the social studies of finance. So again, those works are things that I deem international lawyers ought to engage with. And aside from this ethnographic approach, another useful method is to carry out case studies, which is what I did in my project. I did a case study on the rating agencies, credit rating agencies. So after introducing what I term as the international law of finance, I will highlight two endeavors that are vital in making this move. First, to understand the ideas about markets, law, and their interrelation that inform the workings of international finance. And second, to master the vocabulary and grammar of finance and on the basis of which to approach the financial market on both conceptual and operational levels. So with the first move, in order to make the first move of understanding the ideas that inform the workings of international finance, it's necessary to examine the rules of international finance that are usually, as I term it, protective. So that is this consumer and investor protection rules, which are about saving individuals from dropping through the floor, while the gap between the rich and the poor is not of concern to this protective rules. This is not a critique of these rules, but rather to raise the question of why is the financial market and the law of this field non-challenged towards the rising inequality? So given the complexity of the financial system, the correlation of it to the economy and the broader social and political stakes, it is puzzling that the financial market is most commonly approached as a field in which financial intermediaries facilitate flows of private and scarce capital. So it is perhaps, in order to understand this puzzle, it is perhaps necessary to think of the understanding, the orthodox understanding of the financial market behind the rules we have in the financial market. That is, the operations in and the law of the financial market do not address inequality because of the specific way market participants and regulators approach the financial system. And to do so, what I do in my project is to inquire into the elements of economic liberalism, which I argue that condition this mindset, this orthodox mindset of the financial market. And by offering explanation to the non-challenge of the roots of international finance towards inequality, I hope to promote a better understanding of the ideas that inform the workings of the financial market, to understand how did we come to the world as it is today in the financial market. And to make the second move, to learn the vocabulary and grammar of finance, I deem it necessary to, as I said earlier, either do ethnographic study or case study. And what I did in my project is to do a case study on the rating agencies. So I suggest that one way to move towards international law of finance is through such performances, a case study as a performance of international lawyers and researchers learning the language of finance through practices. And in the process of making the two endeavors mentioned above and pushing for a move towards the international law of finance, I have also noticed 2 points that could usefully facilitate in moving towards the international law of finance. So first, I propose to approach the patchwork of rules by sketching a continuum of compliance pool. This is the idea informed by Frederick Schauer's jurisprudence theory and the useful work by Thomas Frank. So the rules of international finance can and should be located on a single continuum. At one end of the continuum are rules that have strong compliance pull, and at the other end, rules that do not. This continuum enables a better grasp of the legal field of international finance. It provides a vocabulary for the description, and this kind of description can disrupt the idealistic but often simplistic pursuit for more rules. The continuum with compliance pool as the only benchmark also offers a useful lens through which to examine the process of rule making, the roles of different actors in this process, the over and under inclusiveness of these rules, and related to which the actual effects of the rules of international finance. And this continuum draws attention to the rationales of rules and elements taken into consideration by the decision makers, and it could usefully explain the different compliance pool of rules. From there, it offers insights into Jews and their potential in achieving the desired outcome. And the second, I propose to situate the cornerstones of international financial architecture on a spectrum, with the cornerstones that are most directly linked to the real economy and thus rather practical on one end, and the cornerstones that are constructed out of the market participants' desire for such cornerstones on the other. An example of the former of the cornerstone linked to the real economy would be the payment system, that regardless of what market participants perceive of it, the payment system is practically serving transactional purposes. And an example of the latter would be the rating agencies, that I argue through the case study that the rating agencies are the cornerstones of the financial architecture because of the market participants' desire for the credit information of investment. And having sort of proposed or having introduced this project of a step towards the international law of finance, perhaps the interesting questions would be moving forward, what could we do? And I'll just quickly shed some thoughts on this. Perhaps the way to do this is to do a sort of an intellectual history. So to look at the genesis of ideas that informed the practice in the financial market. So something I've been thinking has been, how do the ideas and practices and existing rules, if there's any, in the financial market, in legal academia, and in the law, sort of interact and affect each other. So I tend to think this as a process instead of a translation, but in a way mistranslation. Because by looking at a lot of the studies in financial economics, what I figured is that the authors are well aware of the limits of their work. So the Black-Scholes studies on derivatives and so on, they're well aware of what might be the limits there, but then somehow it's transformed into financial market practices. And then in a way, somehow this also affects the legal practices and the ways we understand it as lawyers. So how does this come into interplay? That's something that I'm interested in. And another way, of course, is to propose and to hope that international lawyers would be engaging with more, critical international lawyers would be engaging with more detailed mechanisms on the financial market. And we have some really interesting works going on that I'm aware of that, for example, Daria at the Lund University is doing this project on European Green Deal and the financing aspect of it. So as an example of the things that international lawyers could be doing to expand this field and I'm still in the process of trying to figure out more of what really can be done in pushing towards the international law of finance, if this makes sense to you, and I welcome any comments, questions. Thank you.